So we need to talk about a recent 9-0 unanimous ruling by the Supreme Court involving the Fourth Amendment's protections of when excessive force by law enforcement actually impacts your rights. This ruling is huge and now may impact another case currently in front of the Supreme Court, which is set to be heard at oral arguments in just a couple weeks. So let's break down what just happened in this critical case and how this is impacting another case going forward. Now, before we jump into this video, I want to thank the sponsor of this video, which is the Wellness Company. In an emergency, every single second counts. Whether you're at a shooting range, you're on the road, or traveling with family, being prepared can actually save your life and save your family's life. The Wellness Company's medical emergency kit puts urgent care at your fingertips. Their kits are compact and ready to travel, and inside you can get 8 life-saving medications, and they can cover over 30 common conditions when hospitals or maybe urgent care isn't available to you. And if you're worried about things like expiration dates, a US military study published in the National Library of Medicine found that 90% of 100+ core drugs remain safe and effective up to 15 years beyond the listed expiration date. And with that, each kit here by the Wellness Company comes with a detailed step-by-step guide from the Wellness Company and their medical board, giving you confidence of how to handle these medicines and how to use them and how to use these kits in emergency when really time and all of this really matters the most. So don't leave your safety to chance. You can get this medical emergency kit today by going to twc.health/scholar and use the code SCHOLAR to save up to $30 plus free shipping. And all of this is only available to US residents. So if you're a US resident, this kit is available to you. Again, I will link it down below in the details section and in the pinned comment, and make sure you use my code SCHOLAR to get $30 plus free shipping. As I mentioned in the intro, in this video, we're going to be discussing a recent 9-0 unanimous ruling by the Supreme Court. The new unanimous ruling by the Supreme Court came in a case called Barnes versus Felix. This new lawsuit should be on everyone's minds because it involves how courts must now analyze situations like this one going forward. Although this case is not directly dealing with warrantless searches and seizures, this case is going to impact another case which is currently in front of the Supreme Court dealing with that very issue. Now, the facts around this case are as follows. Essentially, Officer Roberto Felix Jr. was a police officer who pulled over an individual named Ashton Barnes for suspected toll violations. Essentially, I believe a Houston freeway picked up on camera some toll violations of this vehicle, so the individual here, Ashton Barnes, was pulled over by the police officer. Officer Felix ordered Barnes to exit his vehicle, and Barnes opened his door. He acted as if he was going to exit the vehicle, that he was going to leave the car, but then he attempted to drive away. Now, reacting in a split second, the police officer there decided to jump onto the ledge of the floorboard through the open door. So since the door was open, he can kind of jump on the ledge of the vehicle as it was driving away. As the car was driving away and as he was clinging to that vehicle, he then decided to draw his weapon and then he shot Barnes twice. In response to this, Barnes' mother and father decided to sue Officer Felix on behalf of Ashton Barnes, alleging that the police officer violated Ashton Barnes' Fourth Amendment right against excessive force. The district court granted summary judgment in favor of the officer there, applying the Fifth Circuit's moment of threat rule. The Court of Appeals affirmed, explaining on review that the moment of threat rule requires asking only whether a police officer was in danger at the moment of the threat that resulted in his use of deadly force. Under that rule, events leading up to the shooting are not relevant and cannot be considered. Here, the precise moment of threat, according to the Fifth Circuit, was the 2 seconds where Officer Felix was clinging to the moving car as Ashton Barnes attempted to escape. And because Officer Felix, in the eyes of the Fifth Circuit, could then reasonably believe that his life was in danger, the panel there in the Fifth Circuit held that the shooting was lawful. This case eventually made its way to the United States Supreme Court, and the question the Supreme Court answered in this ruling is whether courts should apply the moment of threat doctrine or something else when evaluating these types of Fourth Amendment claims. On review, the Supreme Court issued a 9-0 unanimous ruling, and they held that a claim that a law enforcement officer used excessive force during a stop or arrest is analyzed under the Fourth Amendment, which requires the force deployed be objectively reasonable from the perspective of a reasonable officer at the scene. The inquiry into the reasonableness of the police force requires analyzing the totality of the circumstances. That analysis, they state, demands careful attention to the facts and circumstances relating to the incident. So in this case, the Supreme Court rejected the more limited moment of threat analysis and instead applied a totality of the circumstances approach. The Supreme Court stated that most notable here, the totality of the circumstances inquiry has no time limit. While the situation at the precise time of the shooting will often matter the most, earlier facts and circumstances may bear on how a reasonable officer would have understood and responded to later ones. Prior events may show why a reasonable officer would perceive otherwise ambiguous conduct as threatening or instead as innocuous. They state that a court deciding a use of force case cannot review the totality of the circumstances if it has on chronological blinders. They concluded by pointing out that the court here does not address a separate question about whether or how an officer's own creation of a dangerous situation factors into the reasonableness test. So the main thrust of this ruling was rejecting the more limited scope of analysis applied by the moment of threat rule by the Fifth Circuit. Instead, the Supreme Court orders lower courts to look at the totality of the circumstances before, during, and after potentially an incident to get more comprehensive pictures of whether or not the Fourth Amendment was violated. Now, during the oral arguments in front of the Supreme Court, there were some concerns about cases where police officers maybe are failing to identify themselves and someone in response exercising their Second Amendment rights to self-defense or protecting themselves. And the Supreme Court said limiting those type of cases and reviews to the moment of threat analysis kind of overrides other fundamental rights like the Second Amendment. And so they had concerns about police officers kind of manufacturing situations, engaging in activities that put other people at risk, potentially not identifying themselves, or these types of wild raids that go on where someone responds because they have no idea that police officers are raiding their homes. So in essence, the Supreme Court found that courts must look beyond just the moment of the threat and instead look at the totality of the situation. The Supreme Court, because of this, just issued their mandate sending the case back down to the lower court. And this does not essentially mean that the Fifth Circuit or the District Court will find in favor of the individual here, Ashton Barnes, or find in favor of the police officer, but instead they're going to have to re-review this case. And instead of looking at the limited moment of threat analysis, they're going to have to look at the totality of the circumstances. Now, this case, like I said, is even more important now because it's potentially going to impact everyone's Fourth Amendment protections against excessive force. But also now this is critical for an upcoming ruling in case that is now developing at the Supreme Court level. This is because there's currently a challenge at the Supreme Court level, and this case is called Case versus Montana. And recently, the Trump administration just asked for participation in the oral arguments on behalf of the state of Montana. And this upcoming Supreme Court argument deals with prior Supreme Court Fourth Amendment issues, and expressly Barnes versus Felix is one of those cases that is mentioned. In the recent notice the Trump administration submitted to the Supreme Court in where they're asking to join the arguments, they say that they should be able to join because the United States has previously presented oral arguments as amicus curiae in cases concerning the interpretation and application of the Fourth Amendment, including cases involving emergency aid. And there they mention Barnes versus Felix. They state, "We therefore believe that participation by the United States in oral argument in this case would be of material assistance to the court." So since the US government argued cases like this Barnes case and the Caniglia case in the past, and potentially those are going to be brought up at the Supreme Court during the oral argument, and it's been brought up in some of the briefs, the United States government and the Trump administration are now asking to participate in another Fourth Amendment case that's pending in front of the Supreme Court. This Barnes ruling was big and it's currently moving forward at the lower court level, but also now it will likely pop back up again at the Supreme Court level in just a couple of weeks during those oral arguments. And again, those are dealing with the Fourth Amendment, and it's a similar Fourth Amendment challenge. It deals with similar issues, and those oral arguments are going to happen in just a couple of weeks on October 15th. So this is something that we're going to be watching closely to see, how does this play out, and how does the Barnes 9-0 unanimous decision issued prior, which struck down the moment of threat rule, how does that impact this other case that is currently pending in front of the Supreme Court, also dealing with the Fourth Amendment. So as we get more information, as it develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, you can check out my website, armedscholar.com. Over there, we have a lot for you guys, codes, coupons, deals, all of that you can check out. We also have the free legal guide that you can sign up for. But again, if you're interested in any of that, you can check that out at armedscholar.com. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.